I am Bill Rochelle, columnist and editor-at-large for American Bankruptcy Institute. My column on the ABI website, appearing on Friday, August 7, talks about a very interesting opinion from the Third Circuit by Circuit Judge Stefanos Bibas. Essentially, Judge Bibas tells us that for these many years, we have been using the wrong language when we talk about standing of a creditor to pursue a claim that might belong to the estate. Essentially, it amounts to this. Imagine a situation in which a creditor wants to pursue a lawsuit against a debtor that may or may not belong to the trustee or to the estate. Typically, in those circumstances, we as lawyers or courts will say that the creditor either does or does not have standing to pursue the lawsuit because it does or may belong to the estate. Standing is a constitutional concept because if there is not standing, then there is not a compliance with the case or controversy requirement of Article 3 of the U.S. Constitution. Judge Bibas went and consulted Supreme Court authority and said that no, in these circumstances involving the right to sue on a claim that may be property of the estate, it is not a question of standing. He said quite clearly that a creditor in these circumstances, even if the creditor is pursuing a claim of the estate, certainly does have standing. Judge Bibas said the question is not standing. It is a question of merits. It is a question of the statutory authority to pursue a claim. So what Judge Bibas did in the case before him that I reported in my column was to say, yes, the creditor does have standing, and then he went to pursue the question of whether or not that creditor had statutory authority to pursue the claim. Now, this is, I think, a really important decision that practically everybody ought to read because one time or another, we are all going to deal with questions where someone is trying to pursue a claim that may or may not be property of the estate. And Judge Bibas is telling us that the concept is not standing. Rather, the concept is statutory authority to pursue the claim or not. As I said, I am Bill Rochelle, ABI's columnist and editor-at-large. I will return same time next week with, I hope, an equally interesting decision somewhere from the bankruptcy or appellate courts in this country. Until then, good day, be well, be safe, and I want everybody back, as I said, same time next week. Good day.